We are back on the record with 2022 CV 369350. We have now selected a jury. We've got two alternates selected. There were no objections raised to the manner or method of selecting that jury. And the parties have now indicated they're ready to begin opening statements, which I will and have indicated after conferring with counsel that I would cap at an hour per side. Is there any reason we can't move forward on behalf of the plaintiff?
No, Your Honor.
All right, on behalf of the defendant?
No, Your Honor.
Okay, so again, feel free. You can start sharing your screen from the outset, move out the well of the courtroom. Time is yours. With that, if we could bring in our jury. Y'all can be seated as we come in. We're standing for you.
Thought I could get in through here. I can, sorry. Look at all these guys. Yeah, we're good.
All right, thank you. Please be seated, everyone. Welcome back, members of the jury. As I indicated, we're now ready to begin opening statements. And so plaintiff may begin when ready.
Thank you, Your Honor. Ladies and gentlemen of the jury, Your Honor, open counsel, on behalf of my client, Simon Reynolds, the owner of Reynolds Renovations and Restorations, I want to thank you for being here today. You're doing an incredible, important civil duty. I know it's not everyone's favorite thing when you think about it, but I think and hope you'll find that this is an interesting and important process in our country. What makes this country what it is to have a jury of your peers look at a case and determine what is the right thing to do, which is what we're going to ask you to do in this case. Just to remind everybody, again, my name is Christopher Burney. I'm an attorney. I've been practicing in Atlanta 27 years. My client, Simon Reynolds, is the owner of Reynolds Renovations and Restorations. He's been a general contractor, residential contractor for over 35 years. And has operated here in the Atlanta area for almost all that time. He's an experienced builder. He's a builder of new homes, and he's a renovator and restorer of historic homes. And you'll hear about that. What we're doing here in the opening statement is we're not arguing the case. It's not our time to tell you why we think we should prevail. What we're doing here is introducing the case to you, letting you get a feel for what this case is going to be about, and get a feel for what the evidence will show in this case. That's what your job is as the judge instructed you. Your job is to determine what the facts are in this case. And the facts are one of two things. It's either what somebody says or what's on a document or on a picture or on a video. Your job is to determine the credibility of that testimony or that documentary evidence. And then at the end of the case, the judge will give you the legal instructions that are the law that apply to this case, and that will be after motions that you probably will not be out here for, and Mr. Craig, who's a fine attorney here on behalf of Ms. Maya, he and I will be talking about those, and we'll be deciding, along with the court's ultimate decision-making authority, what the law is and what the claims are that you will ultimately have to decide. So you may hear about claims here that may not be here at the end of the case. But it's my job here to tell you kind of from our side of the street, what happened here and why we're here today. This is a construction case. It's a construction case. It's a construction case. It's nothing more than that. And the evidence will support that. The defendant is going to try to tell you that this is way more than a construction case. It's a construction case. It's a dispute over a construction contract that was in writing in part, and there are other things that were not in writing. It's a construction case. And it's an old one. This case started in 2019. My client, Simon Reynolds, a renovator of homes, a restorer of historic homes all across Georgia, all throughout the Atlanta area, had a meeting with Miss Maya about building an ADU behind her house at 1261 Grant Street in Grant Park, Atlanta. And so what she wanted to do was to build an ADU, and you may be familiar with that. What is that? What's that mean? It's an accessory dwelling unit, which is a term of art under the city of Atlanta's building regulations, which means it's another house kind of behind a house usually, like the tiny house movements. Those are all the tiny houses you hear. Those are ADUs. This one was going to be special. And it was going to be special because Mr. Ordonez, Antonio Ordonez, who's not a party to this case, is Miss Maya's father, and he was badly disabled. He was a war veteran. He suffered injuries in the war, and he was elderly and badly disabled when Mr. Reynolds met him briefly for the first time. And Miss Maya, to her credit, wanted to bring her father closer to her.
Ma'am, you can step out.
Wanted to bring her father closer to her.
Mr. Brennan, you
so
can pause for a second. You don't need this distraction. Ma'am, you can step out now. Whenever you're ready.
Miss Maya wanted to build a home, small home behind her home that was specially built so that her elderly disabled father, who was bedridden, could be cared for more easily by her. Mr. Reynolds was in full support of that from the beginning. That's all he wanted to do, was to help her do that. That's all he's ever wanted to do. And the evidence is going to show that that's what he did. As best as he could, he tried to be reasonable. He did everything he could. And that's what the evidence will show. So in 2019, they start this discussion. And it takes them some time to figure it out. And here's why, and this is very important. This house was going to be paid for by a grant given to Miss Maya and to Mr. Ordonez due to his status as a veteran. It was going to be granted to, the money for the house was going to be granted to them so that this could be built under the VA, the Department of Veteran Affairs SAH program, Specially Adapted Housing. What's a specially adapted housing? First of all, saying SAH is difficult for me. I'm gonna say ADU, but I mean SAH. It's a specially adapted house, which is a great program that the VA puts on that allows a veteran who is disabled and meets other qualifications under the program to receive grant monies, to have a home built for them that is specially adapted for that person. That's what this program was. Ms. Maya wanted to use the program, and who wouldn't? She's entitled to it. Her father served, he did what his duty required, and he's entitled to this program, and good for them. Mr. Reynolds, through Reynolds Renovations, was all for it, and always has been. And that's what the evidence will show. And so what happened was, they started to go through the process of, well, how do we do this? Now, how do we get the approval for this grant? This is a complicated process. It took some time to do that. Plans had to be made. Designs had to be done. Paperwork, as you can imagine, had to be filled out. This is the Department of Veteran Affairs. It's a government issue. A lot of paperwork had to be filled out. And Ms. Maya, to her credit, did it. She wanted it done, and she did it. And Mr. Reynolds was there to support her and to give her the information so that she could get it done, so that they could get this grant of ultimately it ended up being about $120,000 for them to build this ADU. And so they go through the process, and when they're going through the process, you're going to see that there's different versions of documents, okay? You're going to see a couple of different contracts. You're going to see a couple of different cost estimates. You're going to see cost estimates that include certain things at one point and then later don't include another. And this is a very important thing to remember. Because what's at issue here is what was the contract? What was the scope of the contract for the specially adapted housing? And then what was added on? Because the evidence will show, it will be undisputed, I think, well, probably not. But it should be clear to you at the end of this case that there were other things done at both Miss Maya's property. And let me just, if I may, just walk over here and show you it so you can understand. We've been staring at this for several years, so we see it, but you're looking at it for the first time. Let me give you the lay of the land here. This is Grant Street. This home right here is 1261 Grant Street. This is where Miss Maya lived with her husband, Francisco Maya, and her husband, and I think, or her father and mother lived there until they passed, or until Mr. Ordenius passed. And so what happened was they were this is Dalton Street here. This is in the southeast corner of Atlanta, not far from here, less than 10 minutes. This is the one-story frame house where the Miss Maya lives. And this back here is the ADU that was being added. And there's a street here. The evidence will show there's a street here, and there's a driveway that was added with a gate that was reconfigured so that it would work for this ADU. This is a walkway that goes from the house, from the ADU to the house. The walkway was there. It was granted to them through a previous grant that allowed them to get this walkway built. And it wasn't covered. It was just an aluminum walkway that was there that they had gone through the process to get that granted to them through another process. So that's the walkway. This is the house. This is the back deck. You're going to see that this isn't exactly how it turned out. And that doesn't mean that Mr. Reynolds did anything wrong. It means that he followed the contract and they made changes to it as time went on. And I'm going to talk about that in a minute. But this is essentially the world that we're living in here in this case. This is it. You'll see pictures. We're not going to get into all of them here today. Mr. Craig may show you some. But this is the world that we're living in here. Okay? So there was work under the specially adapted housing contract that's done here. Okay? That's the contract that when we say the written contract, that's what we're talking about, the VA contract. Then there was work that was not part of the VA contract, and that includes the covered walkway. we believe the evidence will show that the covered walkway was not part of the contract, of the VA contract. And the evidence will show that some tile work on the front walkway was not done, was not part of the contract. The VA doesn't pay for anything you want. The money has to go to specifically benefit the veteran and the use that they're trying to do. And so there are things that are outside the contract that were orally agreed on. And if you find that there's no oral agreement, there'll be other ways for you to make Mr. Reynolds whole. But the evidence will show that there was an agreement and that there was payment, but it just wasn't totally complete payment. But so there was the tile work here down the front step. There was the moving of this fence. This is a fence, this dotted line. From here to here, the evidence will show that that's a fence that had to be moved to accommodate the building of the ADU. There's a retaining wall, which isn't shown well in this particular survey, but there's a retaining wall that's also not included in the contract. And that was built from Miss Maya's benefit, for the benefit of the ADU by Mr. Reynolds at a reasonable cost, and partial payment was made by Miss Maya. And then she disagreed with the rest of it and other things, and we fell into a dispute that has led to us here today. This is a construction contract dispute. So there are things that are outside of it. There was also a little bit of work inside of her home. Mr. Reynolds replaced a sink in the vanity bathroom of her home. I'd have to look at my notes, but there's a couple other small things that were done that were outside the contract. But the big ones were the moving of the fence, the retaining wall, the covering of the walkway, and a couple of the moving of rearranging of a fence here. You'll see the details are not that important. You're going to get the details. What I'm here to tell you is what to expect to see in this case, and understand the tone and nature of the case. So they go into a discussion about how much is it going to cost to get this work done. And Ms. Maya knew that one of the things that she wanted to have done at that time was to get the walkway covered. And so they ended into discussions, let's build this house and let's also cover the walkway. And so the original cost estimate that you will see in this case was for $136,000 and change. Okay? This was in May of 2020. So we go from discussions in 2019, figuring out how to do this. Now we're in May of 2019, and there's cost estimates for $136,000. The problem is that the VA does not give builders money to start with. They don't do that. So they had to come up with a way to get Mr. Reynolds money so he could start on a greater project. And that's a phrase you'll see in the evidence. The greater project is the ADU and all the work that Ms. Maya wanted to have done on her property, including the covered walkway. And so you will see the VA contract that talks about the covered walkway, but that was removed from the cost estimate. And you'll see the final, so on July 2nd, 2020, they enter into the first contract. That contract includes a line item for a $16,000 covered walkway. Okay? These are things that you want to keep track of as you listen to this case. A $16,000 covered walkway is included in the $136,000 line item cost. It's a document, it says cost estimate. You'll see it says covered walkway. But they need the money to get started, so they pull this out of the contract. It's not really part of the ADU anyway. They pull it out of the contract and they send a separate invoice. They agree that there'll be a separate invoice for the $16,000. And that invoice says deposit for the covered walkway. What it says. It's indisputable. It's paid by Miss Maya. On October 20th, 2022, they execute essentially the same contract, but the cost estimate for that contract does not include the cost for the covered walkway. Why? Because it wasn't part of that contract. This is a construction contract dispute. And so there's a new contract. There's two written contracts in this case, one July 2nd, 2020, an updated one that's actually approved by the VA. It's essentially the same, except for a few changes to a couple line items, but particularly the removal of the covered walkway. And that one is executed on October 20th, 2020, excuse me. And at that time, the contract price is miraculously $16,000 less. It's not 136 anymore, it's 120. Because that's the contract for the ADU. And so, because that allows Miss Maya to give Mr. Reynolds $16,000 so he can get started on building this wonderful place for her father to live and for her to take care of him, which was Mr. Reynolds' goal from the very beginning through his company. There was nothing else he wanted to do but to accomplish that. And so there's a contract for 120. There's a payment for the 16,000. Now, one of the issues in this case, and it's a big one that you need to pay very close attention to, is what's up with this 16,000? Is this refundable? Because Miss Maya's whole case is, oh, it's refundable. You're supposed to give that back to us at the end. No. You know why? Because the very first cost estimate they had was for 136 that included the covered walkway. Then they revised it so that Mr. Reynolds would have some money to work with to get started and brought it down to 120. It's not refundable. And this is where your experience, knowledge, understanding of how the world works, which we rely on so heavily in this system, is so important. This is where you will listen to the facts that are put in this case and decide what's reasonable. So the 16,000 wasn't refundable, never was. And what happened was Mr. Reynolds built the ADU for $120,000. Miss Maya contributed some funds to the overall project as required by the VA. The VA granted her and her father the rest of the funds, a total of $120,279. It was done and completed. Save a few little issues that had to be done that could have very well been done. The evidence will show that had Miss Maya allowed Mr. Reynolds to step in and make these repairs, accommodations to the property, he's got 35 years. You don't think he can figure out how to fix just about anything? She didn't pick him for no reason. But he wasn't, the evidence will show he was not given an opportunity to cure this contract. And for that reason, he's not liable under the contract, and we'll talk about that later. I'm not here to argue. I'm here to tell you what the evidence is going to show. And so the evidence is going to show that there was part of the contract was for the ADU that didn't include the covered walkway. And then there was, some other things that we talked about. So what happened with the contract? Were there things that happened during it? Yes, there were. What were those things? There were 2 change orders you'll hear about. Everybody knows what a change order, right? Change order is a written amendment to the agreement. The VA required them. So there were a change order. There was 2 change orders done. One, because they couldn't get the windows because of COVID. Remember, this is 2020, 2021. So they signed the contract in October of 2020, and then what happens is they have to go into the planning and the final steps to get this property ready to go. And one of the things they had to do, the evidence will show, is get a variance, because this is a violation of all kinds of different things in the city of Atlanta codes. So they needed a variance so that they could actually build the thing and be in compliance with the City of Atlanta building requirements. So that took some time. That wasn't Mr. Reynolds' responsibility. That was a lady by the name of Shona Griffin who did that. Mr. Reynolds complied, gave information, worked his butt off to help them get all the information together. You'll see they signed 1 million documents to make this happen for Ms. Maya. Did 1 million different things, bent over backwards, the evidence will show. This is a construction contract dispute. And what happened was that took all the way until 2021. And they get a building permit in 2021. It took that long to get the variance and allow them to start building. Mr. Reynolds starts building in the late spring 2021. The contract has a requirement, the evidence will show that it be done within 135 days. It didn't get done in 135 days. I think I didn't probably even need to tell you that. You see where that's going, but it got done. While there are still punchline issues that were at the end still outstanding, we would have fixed them had we been given a chance, and the evidence will show that. So from that point forward, when they start construction, it goes all the way through the fall into the early part of 2022 and February of 2022. And one of the things you're going to get in this case, and I encourage you to look at them, are the text messages. Hundreds of text messages between Miss Maya and Mr. Reynolds, working out every little detail and trying to figure it out. What do we need? How do we do it? What color? Brushed nickel or satin? 1 million questions, 1 million answers. Total cooperation for months. They built this ADU, and then Mr. Reynolds sent an invoice in February of 2022. And from that point on, Miss Maya's tone changed completely. And now Mr. Reynolds, the evidence that we'll see from their claims, is a fraud, a tortious breach of contractor, tortious breacher of contracts, never intended to live up to his obligations under the contract. That's not what the evidence will show. The evidence will show from the text messages, from the emails, from the work that was done, that Mr. Reynolds did everything he could to get this project completed. He's been doing it for 35 years. The evidence will show he's never been sued. The evidence will show he's been part of one lawsuit in all that time. And he brought it. And he won. Because he was owed the money. This is a construction contract dispute. It's not a fraud case. They've got to prove that it's fraud. They've got to prove that Mr. Reynolds had the intent. Listen for the evidence. The evidence will not show there was any intent on Mr. Reynolds' part at the time he entered into these contracts to defraud Miss Maya. Right in his neighborhood, the evidence will show he lives around the block. This is his neighborhood. The guy, Ed Smith, is his main subcontractor that works with him, lives across the street. That you don't defraud people like that. First of all, Mr. Reynolds doesn't defraud anybody. You certainly don't do it with a person who lives 3 blocks away. That's not how you stay in business for 35 years. The evidence will show it didn't happen. The evidence will show it's wishful thinking. And the evidence will show that this is a construction contract dispute. That's all it is. That's all it ever was. So you'll see that there are some changes in the overall contract price in this case. Changes like COVID happened and everything. So remember, the first cost estimate was prepared in the summer of 2020, right? And really, even went back further than 2019. By the time they're building and everything, the COVID is rearing its ugly head. and prices are higher. This isn't rocket science, the evidence will show. The evidence will show that Mr. Reynolds asked Miss Maya for an increase to cover the overages, about $4,700. Things are more expensive, Regina. Can you please agree to pay me a little bit more? Because here are the receipts, everything was more expensive. Regina says, yes, check. That's what the evidence will show. This is a construction contract dispute. And nobody wants to be here, including my client. This has been taxing on everybody, and I know it's been taxing on Miss Maya. She's got a great attorney. They're gonna put a good case up. And you're gonna remember that the evidence will show this is a construction contract dispute, nothing more. We do have to fess up to a couple of things that we didn't do perfectly in this case. Like in every case that's an extended build, there are things that don't go perfect. And we were ready to fix those things. There are some little issues inside the ADU. You'll learn about those. Nothing major. And you'll have to decide, what's the value of that maybe? Or maybe you'll decide it's substantial compliance. The evidence will show that Mr. Reynolds did everything he could to make her happy. At the end of the day, what happened was that we sent that invoice. And we have to own up perhaps that the invoice wasn't perfect. It may have been off in the dollars amount. We're talking the invoice we sent was 70, there was an initial one from 1953, which gave them credit for things that was shortly thereafter determined because of the nature of the tone and the loss of the ability to work together, that those credits were no longer going to be given. So the number changed to the number without the credits. It's about $7,500. $7,500. She didn't pay. The evidence will show that her and her husband Francisco prevented Mr. Reynolds and his team to come back on their property to make the required repairs, unless they brought him, it's different ones, $9,000, $10,000, $11,000. Bring me my money. That's what the evidence will show. We're not going to give you the money because we don't owe you the money. So you're preventing us from fixing this. You'll also see that the evidence will show that in March of 2022, after the invoice from February, Ms. Maya prepares and files with the Veterans Affairs Department a complaint. This builder didn't do it right. Here are the things he didn't do right. Mr. Reynolds, unhappy with that, responds in a lengthy response, and you'll hear about that response, and addresses every issue. And at the end of the day, the VA says, fix these 4 minor things and you're good. We were ready to do it. She wouldn't let us onto the property to do it. We're talking about minor things, punch list things. This is in March of 2022. At this point, the contract was originally supposed to be for 135 days. We're now about 60 days over time. From when they actually got the permit, when they could actually start to work, to when they actually basically provided a substantially complete dwelling. It's not that far over. Given that it was COVID, given the difficulties and the things that had to happen, they had a change order. If I was getting to the change order, they had a change order. So originally, this is the driveway, right? The driveway needs to be, there's an electric fence that goes back and forth. And the driveway was going to come up and there was going to be this is a door and this is a door. Every SAH has to have 2 instances of ingress and egress. So they had this, and there was going to be a little sidewalk that went from here to the driveway. But the problem was that once they got onto the site and saw what it looked like, they could not make it work and have it be something that you could push a gurney up or a wheelchair up. It would be too steep. And that's what the evidence will show. So they asked for a change order. The first change order, I talked about the windows weren't available. So in order to get paid, they had to pull the windows out of that particular phase. And they did, so that the rest of the money could be paid. and the work could continue. The next change order talks about this issue, removal of the sidewalk. We're removing the sidewalk, and what we're gonna do is we're gonna do the wraparound porch. So there wasn't originally supposed to be a wraparound porch, but you'll see the pictures. What happened was, and this is in a change order signed by Miss Maya, that there was a change order done to make a wraparound porch so that you could come out this door and come around here with a gurney or a wheelchair and come out here and get into a vehicle or leave the premises. That was the approved fix that Miss Maya approved, and that was the change order. The retaining wall here, it is, I said it wasn't, but it is on this right here. The tile, the work inside the house, those were not part of the VA contract, never were. The inflation was, but it was a reasonable request and it was paid by Ms. Maya. They're gonna say, well, the VA didn't approve it. It was a reasonable request that Ms. Maya gladly paid because she understood it, because they were working together. Until she got the bill that she didn't like, and until other forces, including her husband, got involved in this and created a situation where no one could work together any longer. And the evidence will show that. So there's things that are part of the contract and things that aren't. They're gonna tell you it's all part of the contract. There's no way that the tile work here or the covered walkway or the retaining wall or the moving of the fence could be part of the SAA. Doesn't benefit the resident, the veteran. It wasn't part of it. It had to be separate. And it was. So our claims in this case are 3 claims. Breach contracts. You didn't pay us the money that you owe us for us to do this work. That's on the VA side of the contract. And also for what we say is an oral agreement, you'll learn later from the court that oral agreements are perfectly enforceable in Georgia. And so it's part of the agreement that they pay that. And we also have a claim called quantum merit, which is a fancy Latin phrase that says as much as you deserve. And it's an alternate claim. So if there's no contract, you'll learn that you can also get recovery because you deserve it. Because you did the work and it's a reasonable sum for the work. And it'd be unfair for the person who received the benefit of it, who needed it done. It'd be unfair for them to receive that and not pay the reasonable value of those services. So it's called quantum merit, which is as much as you deserve. So that's the alternate claim. And then we have a claim for attorney's fees. One of the things we do have to own up to, besides maybe a small error here or two in the billing, which is not material to this case, you'll see that if you look at it with an open mind, is that we filed a lien. We filed a lien in this case because they weren't cooperating with us, allowing us to come in and make the repairs, and we wanted to be paid. And you'll learn in the case that there's deadlines for filing liens. You have to file. We waited to the last possible moment to file. And it got filed and it was filed incorrectly. It had technical errors, which we figured out later. They brought it to our attention. We removed and canceled the lien. Mr. Reynolds canceled the lien. So we have to own up to that. The lien is not impacting their property today. It hasn't been impacting their property since the beginning of 2023. Filed a lien in June of 2022. And it was withdrawn in February of 2023. We have to own up to that. It doesn't mean that they get recovery for that, and the judge will give you instructions. If that claim comes to you, you'll get instructions about that. The evidence will show that they don't have any damages that allow them to recover for that. Those are our claims. Breach contract, quantum merit, attorney's fees. What are their claims? Tortious breach of contract. Tortious breach. Tortious means an intentional act. That's wrong. An intentional wrongdoing. The court will instruct you on that. There's no intention here on Mr. Reynolds' act, and the evidence will not show that he intended anything except to build a nice ADU for Miss Maya and her father so that she could care for him more easily. That's the intent that you'll find here. Nothing else. The next claim they've got is negligence. Negligence because they didn't build the house right. And we'll get into that. They'll get into that. Now, we think that after you look at the errors, if we had been given an opportunity to come and repair them, there wouldn't be anything to talk about here. Another claim they have is slander. That relates to the fact that we filed this lien. Talked a little bit about that. The evidence will not show that they're entitled to that claim because there's no damages. Listen for the damages when they talk about slander. When they talk about the lien, what are the damages? Are they real damages? They're going to say, well, we applied for a mortgage and we didn't ever get the loan. They're not going to tell you is they never got a denial. They applied through some online process. The evidence that they've presented as evidence in this case, you'll see is very scant. There's no evidence about how, if they had gotten the loan, what the terms of the loan would be and what the damages would be. And that's required. It also is shown that to do the slandering, you have to be malicious. There's no evidence of maliciousness here. None. There's only evidence of Mr. Reynolds trying to build this thing for Miss Maya and her father. There's also a claim for fraud. They have a claim for fraud. They're calling Mr. Reynolds a fraud because when he signed the contract with under the VA with Miss Maya, his intention was to never do the work for that amount of money. And there's no evidence of that. And this is why I'm telling you about it, because I'm talking to you about what the evidence will show. I also get to tell you what the evidence will not show. It will not be any evidence that Mr. Reynolds had any intent to defraud anybody, and he wouldn't be in business for 35 years if he did. So the fraud claim is ridiculous and it's got to go. They have a claim for conversion. What's conversion? Conversion is a claim where you say, I had a thing, I liked that thing, and you took that thing, and I asked for it back and you didn't give it back to me. You got to pay me for it. They're talking about three things. One, the $16,000, which is money, which we'll talk about that later, which is incapable of being converted. The second one is the sink that Mr. Reynolds pulled out of the main house, not the ADU, and allegedly took it. And the evidence will show that the sink broke upon removal and was discarded. No one took it. And then the last thing is some lumber, which they say Mr. Reynolds took and used on other projects. He used it in the wraparound porch. There's no conversion of anything. They have a claim for punitive damages in this case, which we're not going to get into what that is because it's not going to happen. But the punitive damages claim applies to the fraud claim, the slander claim, and the conversion claim. Potentially the negligence claim. But because of the reasons I've talked about and what the evidence won't show, you won't be authorized or won't want to find any punitive damages. This is a construction contract dispute. That's all it ever was. And all ever needs to be. And then they have a claim for attorney's fees. So that's what this case is about. There's not going to be a ton of witnesses. There's going to be a lot of documents. And so what I ask you to do is to pay close attention. And this is, unfortunately, the people that don't like to do this, this is a case for note takers. I need you to take notes and to pay attention and write things down. Listen to what people say and don't sleep. You got to stay awake in this case. They're calling my client a fraud. not funny. This is a construction contract dispute. My client's not a fraud. If you find that he made some errors, you'll also find that he didn't get a chance to fix them. So I want to thank you again for being here. I really encourage you to listen carefully, look at the documents, take notes, pay attention, judge credibility, and do what we've asked you to do, which is to apply your own personal experience to the facts of this case and make the right decision. And I think if you do that, you will. Thank you.
All right. Thank you, counsel. Members of the jury, feel free. If anyone needs to take a break, they can, or if you just want to stand and stretch in place. Otherwise, Mr. Craig, whenever you're ready, you can proceed.
Gonna need the screen share.
Well.
That seems to be working.
Oh, yes, it is. I'm sorry. Thank you.
No problem. All right, ladies and gentlemen of the jury, thank you very much for your service. And congratulations, Chris, on an excellent opening statement. Chris is an excellent speaker, and I won't have his polish or his oratorical skill today. He's a fine attorney. But what I can offer you today is a really good, clear introduction to the facts of this case. Over the next few days, there's going to be a lot of information coming at you. A lot of information. It's going to be a flood of detail. There's a lot that happened in this construction project. It took place over a period of years. We've been through thousands of emails, text messages, documents, all kinds of things. It will be, we're not going to show you thousands, but there's just been a lot of detail. It's going to be very easy to get lost. And I agree 100% with Mr. Burney that taking notes would be great. I love seeing that some of you have notepads. I will try to highlight for you a couple of points during my talk here where it will be useful for you to jot down a note or two. So what I want to do is give you just a basic roadmap of the case. Not going to get into the main points that are in dispute. Much of what Mr. Burney spent his time on, I will not try to address in this speech. I'm going to let the evidence come forward and let you all decide, based on the facts, the documents, and the testimony, what you believe is right in this case. But what we really want to do is prevent confusion. So what I want to lay out for you are a few things. The property where this took place, the people involved, the contract that the parties entered into, the timeline of events that transpired, what order things happened in and how long things took. And then the lien that was filed and the lawsuit that was filed. So by the time I'm done, you guys will really understand the big picture. And when the evidence is coming at you, you'll understand how each piece of evidence fits into the whole. So let's start with the property. Now, Mr. Bernie had a great diagram of the property up there, but I don't know about you guys, when I first look at a survey, it's just such a mess of lines and notations and numbers. It takes me a while before I can really understand it. So I'm going to give you some pictures. We're just going to start with a map that shows where everything took place. So here's where we are. It's a little bit south of Grant Park, here in this quadrant of the city. And then here's just a zoomed in map of the street. We have Grant Street here and Dalton Street here. This is Mrs. Maya's property. As you can see, it's a corner lot, and the house, you won't see it here on the map, but I'm going to show you in just a second, is facing east. All right, so this is a north-south street, and this is the house facing east. All right, so now we have an aerial photograph of the property. And it's a little blurry, but the reason why I chose this photograph, I took this off the tax assessor's website, it draws in the lot line. All right, so this shows you the shape of the lot, the size of the lot, and then with the aerial photograph here, you can see some features of the lot. All right. So now another reason I chose this photograph is this is before the construction of the ADU, beforehand. So you can see it's not back there yet. It's a little bit older photo. And what I want you to notice is that this lot, you could pretty much draw a line down the middle. Half of it is house, half of it is backyard at this point. There's a little walkway here that comes up to the front porch. We've got this backyard. There's a parking area back here. I believe this is actually Mrs. Maya's vehicle at the time, parked in the backyard. You can barely see it, but there's a fence that runs here along the north side of the lot. That may become important later, depending on how the testimony plays out, but it's just something to bear in mind. We've got a wooden privacy fence running along here, and actually this fence encircles the whole backyard. There's also a fence down here, and you can see there's kind of you can see the concrete. And what you'll come to understand is that, there's no driveway up here. You come around behind the house and you come in the backyard to park. So the entrance to the property is really back here, and you could see that on the diagram, I think, that Mr. Bernie showed you. So now, now we have a more recent aerial photograph, and now you can see been a lot of work done in the backyard. This is sort of our aerial after picture. And I'm sure what jumps out at you is this kind of bright colored L shape, right? So what is that? This is a roof. So here we have the house, all right? Here we have the back porch, all right? And here we have a walkway that goes through the backyard. And then here's the ADU, all right? Now this walkway, this is a metal roof over the walkway. This is the breezeway that Mr. Bernie talked to you about at some length. And you can see here, you still have parking, and it's obscured by trees, but the entrance to the property here. Okay, so here's a picture of the front of the house. So you all can see how it looks from the front. You can see there's that concrete walkway going up. I guess it was Halloween. Here's the southern side of the house. All right, so as I was showing you on the map, you come down the north-south Grant Street. Then you could come along here, go around the back to Park. Okay, here is the backyard. Now, the reason I put this here after all these other slides is because the perspective's a little different from anything else we've seen. This is before construction, okay? We're standing on the back porch. We're looking back to the back of the property. So this is on the house, looking back to the back of the property. You can see that privacy fence along the north boundary of the property, and it's wrapping around at the back of the lot. And so here's the backyard after the construction has been completed. And now we're looking at the north fence. The ADU is on our left. And here's that covered walkway coming down. That metal roof I was talking about is up here. All right, so that's that shiny metal roof from the photograph we had earlier. So that's kind of how things lay out. That's essentially the problem. And the specific neighborhood they're in is called Chosewood, I believe. Now, we've got an idea of what the property looks like, how it's laid out, how it looked before, how it looks after. Let's talk about the people in this case who were living in the house at the time that the construction project was underway. All right, so at the time we had 4 people in the house. We had Mrs. Maya, her husband, Mr. Francisco Maya, her father, Mr. Ordonez, the disabled veteran for whom the ADU was built. And then we also had Mrs. Ordonez, Mrs. Maya's mother. So Mr. Ordonez was very elderly. As you all know, he was a military veteran. He served in the Vietnam War. During his service in Vietnam, he was exposed to a chemical agent called Agent Orange. And Agent Orange is a really nasty toxin, and it can cause a whole bunch of problems. In this case, by the end of his life, he was completely disabled. He had Parkinson's, peripheral neuropathy, and a host of other degenerative problems that you'll hear Mrs. Maya tell you about in greater detail when she testifies. He was completely disabled, though he was living in a bed, essentially. He was confined to this hospital bed 24/7. He did pass away on February 18th, 2023. So this lawsuit was filed in August of 2022. He passed away about 5 months after that. Mrs. Ordonez, Regina's mother, is now also quite elderly. She's currently living at the house with Mrs. Maya. And she is currently suffering from Alzheimer's, and Mrs. Maya is now caring for her. So I guess I skipped a slide. I do want to further elaborate that the plaintiff in this case is Reynolds Renovations. You all know that at this point. And the defendant is Regina Maya. As Mr. Burney pointed out to you, my client has filed a counterclaim. And so we could call her the counter plaintiff. That is legal term for, her status in the case. But I'm just gonna call her the defendant, rather than tripping over defendant and counter plaintiff every time I refer to her. And Reynolds Renovations and Mr. Reynolds individually are counter defendants. But I'll probably just kind of refer to them informally and collectively as plaintiff. Although technically Mr. Reynolds is not a plaintiff, he's a counter defendant. Here's a picture of Mr. Ordonez. Since he can't be here today to speak for himself, I wanted to at least show you a picture. This is him during his term of service back in the late 60s, early 70s in Vietnam. Not in Vietnam, I believe that was New York. And then here he is actually in service on a military ship during his time of duty. And then I wanted to show you the family, together. And Mr. Ordonez obviously is in the middle there. We've got Regina's
Brother-in-law.
brother-in-law, Regina and her mother and your sister, right? All right. So that's your introduction to where this is set and who's who in the case. Let's talk about the contract between the parties, because that is the foundation of the case. It's the written document that solidifies the terms of their agreement. And I've got a slide here of the contract. This is the first page, so you can kind of recognize it when you see it. If it goes back in the jury room, you'll be able to see it. You're not going to be able to read this, of course, because it's too tiny on the screen. But just that's what the first page looks like. A couple things I can point out. 7 pages long. We've got the date on here. I don't know if you guys can read this. October 20th of 2020 is the effective date. And you see there are signatures on the bottom of the first page. I think they signed every page, which you don't normally do with contracts, but they did in this case. I think that's to just make sure that, it's understood every page is subject to this agreement. So let's zoom in on a couple of key provisions in this contract. The first one, this is the very first paragraph, actually, if we go back. So I'm zooming in right here. All right, so the first one says first paragraph says construction contract. The contract is made on 10/20/2020, the effective date. By and between the following parties, we've got Antonio Ordonez, also known as beneficiary, and Regina Ordonez Maya, all right? And then number 2, Reynolds Renovations and Restoration, all right? So this is who they are, and this is an exchange of promises between 1 and 2, all right? So the terms. Contractor will complete construction at 1261 Grand Street, all right? According to the following layout and site plan, called the plans, prepared by Ms. Shona Griffin, signed and dated by all parties. Exhibit A contains a narrative description, and then we've got the layout, Exhibit B, and the site plan, Exhibit C, all right? So it's pretty clear. Contractor's going to do this work, and he's going to do it in compliance with these plans. And these plans, they're not just, plans that are vaguely referenced. They are actually exhibits to the contract, specifically referenced as exhibits, incorporated into the terms of the agreement. All right, so this is the same slide again, but now we've got one more paragraph right below there. The total price will be $120,279, as outlined in Exhibit D. Okay? So this is an exchange of promises, and the essence of the bargain is the contractor does the work and the homeowner pays the money, right? It's very simple. His obligation is pretty elaborate. He's got to do all of this work. He's got to comply with these plans. He's got to provide this service. Her obligation is very straightforward. Pay the money. All right? Okay, next provision. Construction start date acknowledgement. Construction may not begin until the VA has provided authorization. All right, so the VA's got to give you the green light. Construction will be completed by 135 days after the construction start date. So once you get the green light and you start work, that's when the clock starts running. And you've got 135 days to finish the project. Now, this is important because when the property is all torn up, this is a major disruption to the life of the homeowner. And furthermore, it is, they're waiting to be able to use this. They've got a disabled person who is waiting to be able to use this facility. So the deadline is not just trivial, it's a promise. It's put down in writing, it's part of the contract. One last provision that I want to present to you is this change order acknowledgement. So this is in the contract as well. And this says any substitutions or deviations to the plans and specifications must be approved by the VA in advance. Okay, so if we're going to make changes to the plans, we got to run it by the VA. They're footing the bill for this thing. So, you know, obviously they need to be happy with what we're doing. The builder and the veteran must request approval of any substitutions and deviations using a change order. Okay? The builder and the veteran must request approval. All right? So you can't just go to the VA as the veteran or as the homeowner. You can't just go as the builder. You've got to come up with an agreement about how you want the changes done. And then you go to the VA and you present that to the VA. All right, that's the required procedure. And it says, look, failure to obtain approval may result in delays, payment delays, or disputes, which is right where we are now. But what I want to emphasize about this provision, it's not immediately obvious from this language, but there's no dispute here that the VA is not actually a party to the contract. Okay? The VA didn't sign this. This is an exchange of promises between the builder and the homeowner. The builder is promising to build, the homeowner is promising to pay. And they are getting together in this document and they're saying, hey, we're not going to make changes without consulting each other, reaching an agreement and getting the VA's permission. All right. It's a promise to one another that this process will be followed. All right. So that's the agreement. Those are the essential terms of the agreement. Let's talk about what happened in this case, the timeline of events and how things unfolded. So I've mapped out 5 phases of the case for you guys. This is yes, take some notes, please, because this is going to really help you when we're talking about the case and you're hearing evidence. You can think about, well, what phase of the case does this fit into? You know, what is happening at this point in time? So phase one, I'm calling the contract phase. This is where the parties are negotiating, talking through things, and coming up with the terms of their agreement. They go through a whole process of negotiating, and they eventually sign a contract on October 20th of 2020. That might be the most important date in the case. That is when they sign that contract that I just showed you. All right. So once that contract is signed, we move to phase two, which is the approval phase. All right. Why do I call this the approval phase? Well, we're getting the VA's approval. We're submitting the contract to the VA and doing all of the extensive paperwork that is required to get this grant approved. Because of course the VA doesn't just hand out $100,000. You've got to really, document what you're doing. So the approval phase ends on May 20th of 2021. That's when the work starts. So they get approval, they start work. I'm calling that the end of the approval phase. And that's the start of the construction phase. All right. So once the project is approved, the construction starts, the work begins, and it goes on and on until February 16th of 2022. Okay. So we have quite a long construction phase. Then after that, we have the post-construction phase. This is after the work is done. And what's kind of going on in here is we have an ongoing festering disagreement between the parties about a whole bunch of different things. All right. And I'm going to let them tell you more about that. Because it's going to be hard for me to talk about this without getting kind of, argumentative, which I'm not supposed to do right now. So post-construction ends on 8/25/2022 with the filing of the lawsuit. All right. So August 2022, the lawsuit is filed. And there are 3 points that I want you to remember, though, before I get into the lawsuit. All right. It's that Regina Maya, she did everything that was required of her under this contract. Okay. She paid the contract price in full. You remember the essence of her obligation under the contract was to pay the money. We're going to show you she paid it all. Furthermore, we're going to show you she paid more than she actually owed. So those are kind of the 3 key points that I want you to keep in mind as we get into this lawsuit. With respect to Mr. Reynolds and Reynolds Renovations, we're going to show you that Reynolds Renovations did not comply with the building plans, did not honor the contract price, did not finish the project on time, and made changes without change orders, which resulted in this dispute. All right, so, all right, very quickly, we're going to talk about the lien. All right, that's going to take us into the lawsuit. I kind of skipped ahead of myself, but the lien is important. This is the build up to the lawsuit. This is the post-construction phase between the finish of construction and the start of the lawsuit. The lien that was filed alleges that it says the claimant claims a lien in the amount of $7,536. Okay. It states that so it's a $7,500 lien. All right, and okay, here we've zoomed in on the crucial language here. Claimant claims a lien of $7,500 roughly. on the single family home with accessory dwelling unit and the premises, et cetera, et cetera. Okay? So, it's important to understand this is a public statement that puts a burden on the property. It's an encumbrance on the property. The property becomes unmarketable without satisfying this lien. And I'm going to skip over this timeline of the lien and let's get right into the lawsuit. So the lawsuit is initiated by Mr. Reynolds and his company, Reynolds Renovation. Now, this lawsuit is filed in Superior Court. Okay. And you can see here, I'm just going to show you this document is called the complaint. This is the document that starts up a lawsuit. All right. And what happens is the plaintiff takes this document. It used to be when I started practicing, we would actually carry it down here to the courthouse, hand a copy to the clerk, and they would stamp it with a date. And then we'd have this date stamped proof that we've filed this complaint. And now it becomes part of the public record that this lawsuit has commenced. And it designates the court, the plaintiff, the defendants. You'll notice Mr. Ordonez and Regina were both sued at that time. And, we've got a little case number that gets stamped on there and so forth. And it identifies the parties and gets into some legal technicalities. But what I want you to understand about this case, okay, is that the plaintiff came to Superior Court with a lawsuit to foreclose on the veteran's home. All right, the veteran and his family's home. This $7,500 dispute, which my client will tell you there shouldn't even be a dispute about this, gave rise to an effort to foreclose on the home. And some of you may have heard what foreclosure means earlier. It means selling off the home on the courthouse steps. All right. So they lose title to the property. They lose their home so that your $7,500 claim can be paid out of the proceeds from that auction. All right. That's how this case got started. That's what turned this case into a jury case. All right. So we've got later on, we've got this claim for quantum merit. You heard about that. And also, they sued her for attorney fees. So not only are they trying to take away her house, but they're saying, you need to pay us for our trouble in doing so. So here we have the prayer for relief. All right, we're seeking judgment against defendants in the sum of $7,500. We're seeking a special lien that we're entitled to foreclose on, and we're seeking attorney fees. And oh, by the way, we want a jury. We want 12 people to come in here and settle this $7,500 debt that we contend that we're owed. And Mr. Bernie's a fine attorney. He knows his craft, but I wouldn't put my signature on this. So Mrs. Mai has counterclaims. She was not litigious despite the injuries she suffered. Not injuries, but the financial harm that she suffered as a result of this debacle of a construction project. She wasn't going to do anything, but they took her to court. They decided they want to try and take away her house. And so she counterclaimed. And the more we looked at the case, the more things we found. Breach of contract, negligence, and fraud. And so we're seeking damages for emotional distress, we're seeking punitive damages, and we're seeking attorney fees. So remember, Regina Maya did everything she was required to do under this contract. She paid the contract price in full, and she paid more than she actually owed. The evidence is going to show that. Whereas Mr. Reynolds did not comply with the building plans, did not honor the price, did not finish the project on time, and made changes without change orders, which resulted in this dispute. Thank you, ladies and gentlemen of the jury.
All right, members of the jury, I think that we have covered a lot of ground today. And so thank you again for your patience. And we will resume tomorrow. Again, at 9 o'clock is when I would expect us to call in and get rolling with the evidence. So unless there are any concerns, feel free to hold back and address those. Otherwise, we'll see you back tomorrow. Thank you so much.
That's the jury room.
I'm sorry, let me get a juror number for you whenever you ask a question.
19.
19, yes, sir.
In the jury room at 9.
That's exactly right.
All right.
And feel free to turn the light on when you're all there, but we'll be checking. All right. Thank you. All right, unless council want to jump in with something here, let's get back to some housekeeping to make sure we're on track to dive right into it. Anyone? All right, seeing no takers.
Oh, I'm sorry, Your Honor, I was just getting.
I
my
know.
thought. I mean,
Feel free. Have at it. What do you have?
So one, you know, the Agent Orange thing, I didn't think he was supposed to raise that up in opening. It came up a couple times. I would just, I mean, I don't think James did it intentionally. It's,
I should have made an explicit ruling on it. I think you can preserve the objection for the record. What he said to me didn't cross the line in terms of requiring a 403 exclusion. I think there is some intrinsic evidence, a background about the case that is admissible. If you need a limiting instruction, I think we're going to be telling them that this case isn't about sympathy. I just didn't see it cross the line as to where I would have granted or sustained an objection. But I think it's a fair point. I was actually expecting you to get up there and interject.
I
And so,
resisted. He was kind enough not to interrupt me. I gave him the same courtesy but I do think I owe it to my client to raise it up.
I understand. And I would say as a matter of the record that you did raise it as a motion in limine. And I would say that I denied it before openings. And so to the extent that denial is error, the claim is preserved.
Thank you, Your Honor.
Raise that right. All right. Anything else?
I didn't see them raise a slander claim. Is that not an issue in this case?
He may just not decide to talk about it. I think he's still going forward on all his claims.
I didn't talk about it. I think it's still in the PTO, but
Okay,
It's
just
all
making
in
sure that I didn't miss a dismissal or something. It wasn't listed in your, and I don't know what the effect of that is, but you didn't list it in your list of counterclaims.
in the opening.
Okay, I just want to.
I mean, if you can narrow the issues, that'd be great. If there's some claims you decide you're not going forward on, that'd be good to know before tomorrow.
Okay, all right.
Right? I'm looking in the PTO and you number them as 8 of them on page 4 of the PTO. And if you decide between now and tomorrow that you're deciding, hey, we're just not going to go forward on that one, please let us know so we can update our verdict forms and charges accordingly, because I'll be working on those as we go through the evidence.
I don't think I'm required to list all the claims in the opening though, Ryan.
No, you're not at all. Not at all. I think he's just proactively wondering what happened to that one.
Okay.
And if you did make the decision to drop it, it'd be good to know the earlier the better so we can adjust all our forms and everything.
Okay, yes.
Correct.
All right.
Thank you.
Anything else, Mr. Bernie?
Thank you for a good first day. That's all.
All right. Thank you, sir. And Mr. Craig, we're not done yet. Anything else on your end before I jump into some things I had flagged?
No, Your Honor.
Okay.
All yours.
Let me start with both parties bring in a bad faith claim, which I think is highly unlikely to be resolved through a directed verdict phase entirely. So I think some form of a bad faith claim is going to be reaching the jury for both sides. And in terms of presentation of the evidence, I want to explore and see if the parties, you don't have to give me an answer right now, but you can come back to me in the morning, of whether there is a dispute on the amount of attorney's fees, meaning certainly understand you don't think that there's been bad faith, litigiousness, that sort of thing. But is there actually a need to have an attorney, either by stating in his place or on the stand or by affidavit or whatever, say, here's what I've billed on this case. And if you both agree on each other's fees, we would just have a finding saying, should the jury check bad faith is here, that amount just automatically gets plugged in on the final judgment form and obviating the need for formal proof of the amount. And there might not even be a need to even tell them the amount. You can just say, check the box and attorney's fees will be awarded as a matter of law, essentially. So if you have any initial reactions or oppose it vociferously, we can just go ahead and move on. But just something that might save some time.
My initial reaction, Your Honor, would be that I think we need to see what claims survive. And if the fees are broken down by claim, if some claims do not survive. Our claims are alternative claims, one in law, one in equity. So they're pursued simultaneously on the same facts. But the other claim, his claims are different claims that require different elements of proof. And so I think for him to recover, he will have to show that he's broken down his claims by claim, his fees by claim. And I'm not certain that he's done that, but I also have not thoroughly looked at his claim. We just got all his exhibits on Thursday. As you might imagine, there's a couple things happening between now and then. And so I'm going to look at them and we'll reserve the right to raise that up again.
Okay. Any response, Mr. Craig, or anything you want to add?
Well, I'm in favor of stipulating to the amounts of the fees, just because I think that would get us through this process faster than, having to do the whole runaround of presenting evidence on fees. But I do think Mr. Burney has a point that some of the claims may not survive directed verdict. I would, of course, submit that those would be his, but we might want to punt the issue until directed verdict has been heard. Although I guess
You kind of eliminate the point.
part of the, yeah.
Something to think about. I also don't know if it's as, my understanding is it's not as strict a requirement of, even if you haven't allotted, I billed 30% to claim one and 20% to claim two. I don't think the law actually requires that if they're intertwined and intermingled. And so, but that does become a factual issue as well. So if Mr. Burney wants to challenge that aspect of it, then he has every right to. But if you think that there isn't a valid argument or worthwhile one to be made, then that's a decision you can
I
think
certainly
about.
don't want to overburden the court with this question, but I don't think all that are claims are intertwined. I mean, the slander claim is distinct from the fraud claim on different facts.
I guess by that, I mean, not so much the facts as the work done. Like, is there anything that he did that he billed solely as a result of the slander claim? I think would be the point in question here when you're tallying up the attorney time. And if was there a certain motion he filed just because of that one claim that's now dead? That's going to be based on the record I've seen. It wasn't a lot of motions practice, but I don't know what's going on behind the scenes in discovery, and so maybe that's something y'all think you need to get into the weeds in to determine the exact amount of attorney's fees that are due should the jury come down on 13-611. So I put that out there. We can address it in the morning when y'all have had a chance to think through it. And then the other thing that I'd promised to come back to, and as you might have already gauged, is I think I've had no concerns whatsoever on how well the parties have been presenting everything so far and how efficiently it's been going, and so this isn't intended as a punishment or anything like that, but I do still feel like there is a role for time controls imposed. And as I mentioned at the pretrial conference, there's a number of factors that would go into setting that, which is, and I'll just summarize them now that we're on the record, which is one, I would want to hear input on what each party thinks they need to present their case in chief, as well as cross-examination. Assessing exactly what it is that the witnesses are going to cover, the number of exhibits, the complexity of the case. Three, I would emphasize that these are going to be flexible time limits, meaning if good cause is shown that I ran out of time, but here's why, that I can allot more time. with the caveat that that original time estimate is not one just pulled out of thin air. It's going to have some gravity to it, I think is the term I used. But that things come up. If you call a hostile witness like Mr. Maya, and I get the impression he's purposely evading direct answers and eating up your time as a matter of, deviousness of strategy, then that's something I think that you get credited time for. And so the purpose just being that we gave the jury a promise and that we can set an umbrella that we can hold to. So other caveats there I could mention if need be, but I think I kind of explained it. You've seen we've got our clocks promptly displayed here in the courtroom, counting down in real time. I'd be pausing it for objections or bench conferences. And the time is, you make of it what you will. And then I will kind of leave y'all alone to present your case without feeling the need to jump in here with, 403 cumulative sua sponte rulings and that sort of thing. That's, the intent behind it all. So again, I'll just always, since you're plaintiff, Mr. Bernie, I'll let you kind of dive in first and address anything and you want to say in response, and then that if I were to put on the time control, what the number would be for your case and cross.
Thank you, Your Honor. At the outset, I'd like to say that I totally respect the court's ability and authority to do that and to set time controls. On behalf of my client, I object. We waited our time to have our case heard, and putting a case on in front of a jury is a difficult task. There are things that are coming from different directions. You're responding to testimony, objections. There may be an issue with an exhibit. We're going to try to put the case on as efficiently as possible. I guarantee I will make a mistake that will slow us down at some point because I've never had one where I didn't do that. I'm just telling you that so that you understand that it's not our intention to drag anything out. We want this case to be over as quickly as possible. As a philosophical statement, though, I think as an attorney practicing, I don't like the time controls. And I just want the record to note that. I don't think it's, I understand why the court wants to do it, but I think it's a disservice to my client and to Mr. Craig's client. Right? Not in any intentional way. I understand what you're doing. You're running your docket efficiently and you have the right to do so. But if you, to the extent that you want to hear what from the bar about that, that's my point to that. Having said that, I know that I said, in our pretrial conference, you asked us quickly and I gave a quick response. I said we could do it in 45 minutes. I think today you said I could do it in 25, which I know I can't.
No, that was a misstatement on my part. I didn't mean to. And again, that's not something I'm holding you to. Let me let you finish.
I mean, I would hope that I could be through with Mr. Reynolds if we start right at 9 o'clock by, before lunchtime and could turn it over to Mr. Craig, at that time. If not a little bit before. That would
I thought you said you were calling 3 witnesses though.
Oh, my entire case?
Right.
That would be probably more like 2 o'clock tomorrow afternoon, I would think, Your Honor. We're still making a decision about Mr. Maya. And so I know it's going to be Mr. Reynolds and Miss Hine. And so that's, 2 or 3 o'clock tomorrow, I think we would be complete with our case.
So to break that down, and again, this is why
If you're saying including his time to cross it.
I'm not necessarily. So I get your point. If he wasn't crossing though, a full day, as we mentioned, as long as there aren't any huge curveballs, is about 6.5 hours. You go to 2 or 3 o'clock the following day, and that's another 4 to 5, right? 9 to 12, 1 to 2. So essentially what it sounds like you're asking for is like 11 to 12 hours for your case in chief and cross. But that's assuming, I get what you're saying, that his cross is roughly half that, thereabouts. Again, this is, look, I'm going to confess, this is somewhat uncharted territory for me. I'm going off case law from other jurisdictions and how they've implemented this. And the paramount concern being that, the exclusion or prejudicing the case so that y'all aren't able to present it effectively is error. And that's not the purpose here of what we're trying to do. And I'm not trying to set a time where you feel like you're having to move in fast forward motion. There should be a lot of leeway. This isn't supposed to be a sprint, but at the same time, it is just setting something that holds us accountable. And that's the primary motivation. So, so I would put it back to you, pretending that he didn't say a word throughout trial. how long do you think it would take for you to get through all your directs as well as your crosses of potentially the 4 witnesses that he said he would call? That's the number I'm after from you.
I see.
And so while you think about that, let me turn over to Mr. Craig to complete the record on anything and everything he wants to address on this issue.
Well, I mean, I think we all want to get this done by Friday morning. But this is just, this case is kind of a monster with, in terms of how much factual detail is involved. There's just, there's a lot of material potentially to cover. I think Mrs. Maya's testimony is going to take, I mean, I would love to have 6 hours.
For her testimony alone.
Yeah.
Okay.
I don't know if that's really realistic in terms of the court's calendar, and I don't want to, you know, displace these criminal matters that I know are very weighty. But so I don't know. Maybe I could keep it to 4, but and I could aim for that. But you know, she's got to be able to tell her story because this is. There's a lot that happened.
I mean, you can tell the story of Lawrence of Arabia in, I think, 3.5 hours. So just what is it in 4, right? That needs to be covered here. I'm not trying to belittle the point, but I have to say that, you know, I would think you were going to tell me that it was 4 hours for the expert, because that's going to determine what was the workmanlike standard of care and how you prove the breach and the negligent construction. But just to give me 4 hours of background, I mean, that's where, even if I have nothing planned at all Friday and I just, you know, have no cases whatsoever, I think I would still be jumping in here with a 403, just prodding you along every other question if we were in hour 3 or 4 of why I needed to build this and how important it was to
won't be
me.
background, Your Honor. It goes into the contract and then the communications between the parties during the course of construction. And then what happened after construction. And actually my expert, ironically, I think I could wrap that up in less than 2. Because really, you know, in terms of what's wrong with the property, I think that Mrs. Maya's lay testimony on that topic is actually almost sufficient in and of itself, because these problems don't take an expert to identify. You know, like if the electricity doesn't work, the electricity doesn't work. So I can give you a very short expert, but the heart of my case is going to be her testimony. And so I need at least 4 on that. And it's not going to be wasted. It's not going to be just exposition. This is going to be her telling what happened.
All right. Any other input y'all want to give me before I think I have to just kind of weigh in here and use my best judgment here of a starting point?
Thank you, Your Honor. All I can say is that it's exceedingly difficult to gauge how long it's going to take. A lot of factors dependent on it, and they're not all under my control. We had a case in front of Judge Besson a couple of months ago where it took 30 minutes because we couldn't get the Zoom to work, and that wasn't our fault.
And I'm not saying I would attribute that against you.
I
Something like
understand, but
that.
it just creates this tension on the lawyers that I think is difficult to keep thinking freely when this kind of, you know, I don't want to sound like a crybaby because I know what you're doing, but I'm also trying to stand up for what I think is, you know, what I feel like is the just administration of a case. And I don't disagree with you. I understand why you want to do it. I hope you're not taking that way. I'm not criticizing you. I'm just giving my honest opinion as a member of the bar. I can tell you that I will do everything I can to keep it quick and short with Mr. Reynolds. I think, like I said, that I could finish with him before lunch. If we start in the morning, I could get done with him in terms of getting his direct done and turning him over to Mr. Craig. I'm sure Mr. Craig is going to have an extensive cross-examination of him on the issues in this case. I mean, he needs to get more stuff out of Mr. Reynolds than I do. So his cross, I expect, would probably be longer than my direct. That's my guess. I can't I'm not speaking for him, but so that's out of my control. I just don't know how long it's going to take. I've never tried a case with James, so I can't predict it. But I can tell you that it would be my goal to be out in front of the jury by before lunch tomorrow and to turn it over. In terms of Mr. Reynolds, so it goes Mr. Reynolds, cross of Mr. Reynolds. That will determine how much really, and what is said there, what I need Ms. Heim for. And that, so they're all interdependent. And it's, Ms.
Yeah.
Heim's limited in terms of what she would testify to. Mr. Maya is, we're assessing, the impact and necessity of that for this very reason. But we reserve the right still to call him. And all I can tell you is that I hope that I could have my case completely done by tomorrow and turn it over, we can get to directed verdicts. I assume there'll be one from Mr. Craig on our case, argue that, and then turn to his case on Wednesday. That would give 2 days for his case, if needed, and, and some potential rebuttal witnesses. He's only got 2 witnesses. So, to the extent that we would have rebuttal from Mr. Reynolds.
I think you said 4, right? I'm sorry if I noted that wrong. Okay,
Right.
2.
Yeah, he's just got to.
And the expert.
Okay. All right. Well, and yeah, Mr. Bernie, no need to worry about my feelings. This is something I recognize is I wouldn't say the usual practice. I think it's, again, something I'm borrowing from the federal courts but it's something that I have put some thought into and looked at the case law on it. And this is, as I mentioned, it's not a inflexible thing. And, but it is one way, I think, of making sure we are respecting the jury's time and focusing our efforts on the merits of the case and the evidence that we think most deserves that focus. So what I'll do for now, having considered kind of the argument of counsel, the input of counsel, the facts of the case from the openings, from the pretrial conference, from the record, is I will just set a total time limit for both parties of 8 hours right now. And again, when it's directs, it's counting down. When it's your cross, same thing, pauses for acts of God, whatever else comes up. For objections. If it's a 2-second objection, I know overrule it like that, I'm probably not going to get to it in time. And then we can just see how that goes at the end of tomorrow, and we'll take it from there. On the issue, unless there's any other clarity needed there, let me transition over to the issue of the subpoena you raised this morning. Were you able to address that, or any issues about Mr. Maya's attendance tomorrow?
There may be some issues with the attendance on the subpoena, Your Honor. That's part of our, just in full candor to the court. We have a subpoena that was issued and served. We have, there's an issue with whether it was personally served. It was sent by statutory overnight mail pursuant to statute. And the question is whether or not he signed for it. So we have that issue. I'm just bringing it up to the courts.
Well, let's play it out, because in a criminal case, it's pretty straightforward process. I get and sign an arrest warrant, and the DA's investigators go out there and arrest the witness. What would be your remedy here?
Well, honestly, Your Honor, let me just say this. I didn't anticipate that it was going to be an issue for him to appear, because they raised the issue of having to have an interpreter for him. And it's her husband. So
Right,
I
I
assumed
understand.
that was not an issue that we were going to have. It wasn't until today that Mr. Craig doesn't represent Mr. Maya. I've been careful to make that clear, but he did represent to the extent that he made sure that he had an interpreter, so he must be in some communication with him to find out that he needs it, or I would expect so. But in any event, we expected him to be here. He's been involved in this case from the day one.
I mean, so what's the ask though? Like, what would you be asking me to do about
We want to
it?
have Mr. Maya here.
And how do you want me to do that?
Well, I want you to enforce the subpoena if he doesn't appear. And we would ask that he be asked to appear. And if he isn't, then, we'll have to take those actions in. We're talking about it. Part of it is, it's not just the subpoena at all. Part of it is, in fact, weighing the usefulness of the testimony and the risk of the testimony, and, delaying the case unnecessarily. I mean, you've seen there's heated, it's going to change the tenor of this case to something that it's not now, in my opinion, if Mr. Maya testifies. And so that's a strategic decision that we're making, you know, and also in light of the fact that we're trying to get this case done this week, I want to reserve the right to do it, but I mean, it's a tough question to ask about Mr. Maya. To answer, I should say, not a hard question to ask.
Well, oh, I mean, there's only so many remedies I'm sure that are possible. So, you know, that's what I'm going to drill down on. I'm going to emphasize that if I think that you've validly served a witness and they have failed to appear, I wouldn't hesitate at all to use whatever, you know, lawful means there are to ensure compliance. Now, again, like I said, I've described to you, I haven't had that come up in a civil case yet. The witnesses tend to appear. In criminal cases, we're signing arrest warrants all the time, but then those are executed by the state through the DA's office.
Those are personally served by marshals and things like that. So we went through the civil process,
To just serve them, but then to go out and
pick them up. I understand.
who does that? Do you have a bounty hunter or something? Or are you expecting the sheriffs to
I've
just
never
kind
had
of?
to do it either, Your Honor. I mean, they show up and I
Yeah.
didn't really expect this to be an issue, frankly, because of the fact that they asked for an interpreter and then asked that we made sure that we paid for it. So at that point, you
Yeah.
know, we've gone through, you know, if they weren't going to appear, then why are we messing with an interpreter? Or
Well,
there's some issue with
I
this,
mean,
you know,
well,
that's
look,
the problem.
If I'll say one scenario would be that if I sign a material arrest warrant, material witness arrest warrant, and he's not picked up in time for the close of the evidence, that could be a mistrial. And at the point he is arrested, we'll see when we get around to trying this case again. It might be a while.
Like to see if there's a subpoena and
Yes, Your
proof
Honor.
of service.
Happy to show it to you.
I was gonna say. So my client is,
Just why don't you see what he has first and go from there?
All right, yeah, so this is to appear on the 5th of May.
That was the time that we were set for trial. And my understanding is that the subpoena stands as the case is continued. You don't have to serve a new one each calendar.
You have authority for that? Because that's not my personal understanding.
Okay, well, that's how I've always done it. And it's never been an issue. We usually give updates, you know.
I'm worried you may have been relying on the kind of professionalism of a hostile witness, though. So if you can show me that that is actually the effect of subpoenas, but I think subpoenas, it's your commanded to appear on this date. Once that date passes, if they've,
But it says, and from time to time,
okay.
you know, until.
I'm not saying you're wrong. I just, yeah.
I'm not seeing a signature either.
Okay, there's that too, I suppose.
No,
So, I mean, the authority I've seen says that a subpoena must state the date and time for the appearance. And if the date and time for the appearance was today, it has to state that. He has to be subpoenaed to come in and appear at this trial. You know, a subpoena for May, it's not a subpoena for this trial. And there's no proof of service. So, you know, we'd love for him to have an interpreter if they will serve him with a subpoena for this trial.
we have
And
the
that-
ability.
Which we were,
All right, I understand, Mr. Craig. Let me let
would
Mr.
happen.
Bernie weigh in. So issue number one, they're saying he was never served, I guess, even with this May subpoena, perhaps? So anything to that effect,
I mean,
Mr. Bernie?
I understand their point, Your Honor. Again, we were relying on the fact that they asked for an interpreter. We sent the subpoena package out. Mr. Maya is not going to call us up and say, hey, I'll be there. That's not the nature of it. We knew that. But, you know, we also, you know,
I mean,
it's just as dangerous for them to not have him here, frankly. He's a very material witness to the case. And we're going to be entitled I think, to an instruction is why didn't they produce him? We have text messages from him that my client can testify to that were received by him. My client received them. So
You could get them introduced that way,
I mean, I can get his testimony introduced, and that's what I'm saying is that, you know,
potentially.
I'm not trying to make it difficult. I mean, I
I don't think you are. I'm just having to take it
I
one
understand.
issue at a time. And what I'm hearing is set aside this, does a subpoena roll on indefinitely, until the witness is actually needed. They're now saying you didn't serve him with that May subpoena, and I'm not hearing you contest that fact now, or that point, rather.
I can't contest it, Your Honor.
Okay.
For some reason, it wasn't signed by him. And that's an oversight on my part, I have to admit to the court. I thought it was served pursuant to the statute. I also thought, like it's done in other cases, that it's been honored from calendar to calendar. But, if you're not going to honor that, then I'll have to go do some digging on the research and find out who's correct.
Well, the calendar to calendar, I thought you're saying if you didn't serve him to begin with, then the calendar doesn't really matter,
No,
right?
that's fair enough.
So if you can show, or if you also are saying that you think you've been misled in some way, and that now you're asking to continue this case in a mistrial because you think you've got the ability to do that. I don't
think
know.
it's reasonable to assume when they're calling to make sure we have an interpreter that the man is going to be there. It's her husband. It's not some
And
third
that,
party.
and I'm open to that argument because of this,
That's what we relied on,
this issue.
honestly, Your
I mean,
Honor. It took the pressure off of it that, well, they're making us pay for an interpreter. Surely he's going to be here. Why didn't they just say he's never been served with a subpoena? We would have served him.
right. I mean, look, I'll echo.
It's a representation by omission that we relied on. They didn't say, they didn't say, they should have said nothing. And then we would have taken our own action about the interpreter and probably looked at the subpoena. But no, they said, you have an interpreter. We need to have an interpreter and you need to pay for it. To me, that is, a representation in omission that they should have said, Chris, there's no subpoena. He's never been served.
We've been expecting a subpoena. Like, we didn't have any idea they were going to come in here with a May subpoena that was never served. He's on the pretrial order. They're saying, we're going to call him. We're saying, okay, this witness speaks Portuguese. We need an interpreter for this witness. We're waiting and waiting for a subpoena to arrive. There's no subpoena, and if you don't subpoena your witness, this guy's not a volunteer for the party that's suing his wife. And he's not my client. He doesn't listen to me. I'm not advising him. He's not that cooperative. Yes, he's her husband, but spouses are not always going to fall in line with what their spouse wants them to do. Spouses do horrible things to spouses. So we can't assume that she pulls his strings like he's a marionette and he does whatever she wants. It's their job to serve a subpoena. It's not hard. There's a form, you fill it out and you send it by mail. And if the witness signs for it, you're done. That's all they had to do. We were expecting them to do that. We had no reason to believe that they would fail to serve him. And I can't tell him, you need to be in court as a volunteer for the opposing side.
All right, Mr. Bernie, if you have any last thoughts here, anything else you want to add?
No, Your Honor.
I think, Mr. Bernie, you need to make kind of a strategy decision of just how you want to present your case. I would say that I'm willing to take witnesses out of order. So if you can get them served before the evidence is closed Thursday, start pounding the pavement. But if at this point there is a witness that was never actually served, I don't think we can expect him to be here or expect that to end what we've done
understand.
already. Now, that being said, I do think your point about the kind of indications and how you were led are well taken to me. I think this affects whatever ruling I was going to eventually make on the interrogatory issue and the witnesses that you wanted to introduce because they weren't listed on the interrogatories. I think I'm more inclined now to say that that you would be able to get into that. and those witnesses, just looking back at the docket and seeing how things are progressing here. I mean, ultimately, I think the jury should get and hear all the relevant evidence that and be able to take the facts as they come. And so these kind of procedural hangups, as long as there's not some unfair surprise, I just see those as an unfortunate reality of kind of what we have to work through. But you know, that's where we are at this point. And as you have asks or motions to make, I'll consider them.
Understood. Thank you, Your Honor.
All right. What else?
I don't believe I have anything else.
Any other motions in limine? Anything else I can address?
I don't believe so, Your Honor, not from
All
the
right.
plaintiff. Thank you.
All right. Anything else, Mr. Craig?
No, Your Honor. Thank you very much.
Okay. All right. Then let's try to be here ready to go 9 a.m. I think the courtroom will likely open earlier than that if you want to get in here and start testing, making sure you're on the Zoom. You can share your screen, audio, visual, whatever else you need. And in terms of exhibits, just thinking through what needs to actually be printed, what doesn't. Please don't be showing any exhibits on the screen before they're actually admitted and tendered unless there's an agreement from counsel. And then y'all can get back to me again about whether we require formal proof of the amount of attorney's fees. I'm seeing, I think your client wants to be heard.
Okay. My client is wondering and interested in this YouTube. You mentioned that the cases are
Yeah.
displayed on YouTube or?
Sure. Actually, I think we're live right now. And then so at the end of every day, it'll be posted to the channel. I have to actually look up the channel name. I don't remember what it is, but I think there will be potentially dozens and dozens of views.
And my client would, I guess, his next question is, how does that impact sequestration?
Of witnesses. So let me answer one question at a time. If you're wanting to use this in preparation for closings or for whatever else, the YouTube channel is at Judge Scott McAfee, and you should find that there. And I think I have that. It's in our case management order as well, kind of flagging that YouTube issue. So in terms of sequestration, what I would direct the parties is that the rule is designed to make sure that the parties are not supposed to be knowing what's being testified about in court. And if we get some inkling that they have, that can be grounds for exclusion or grounds for, a cross-examination, a topic on cross-examination. So I would instruct the parties to tell their witnesses, those that aren't allowed to be in the courtroom the entire trial as it is, that they should be telling their witnesses and all potential witnesses that they're not to be going on YouTube and watching any of the proceedings. And you can question them if you suspect that is what in fact occurred. But just like you would to a witness out in the hallway, an attorney isn't allowed to go back there and summarize what was just testified to. The attorney should also be letting them know, to the extent that they even think they do, that they shouldn't be watching the live stream of any prior proceedings until they're excused as a witness. Any clarification on that?
No, I just had not known about this, or, I mean, I've seen judges that have it. To me, it's a question for the jury. I know you gave the general, don't read or look at anything about this case.
If anyone wants me to specifically instruct them, don't go on YouTube, I can do that. I generally don't say that because most of the time they don't know that it's on there. So
Right.
why give them that temptation? But I'm willing. I'm at the party's discretion there, or whatever preference.
About you, if they Google you, I assume it comes up pretty quickly.
There might be some other things. I don't know. I don't know if the YouTube would be top of the hits, but
Oh, well, in any event, I hadn't thought about it much. My client was wondering about it, and particularly in the matter of sequestration of witnesses. Again, for what my insight is worth, it might be better to not display it until the case is done, but that's I don't even know if it matters.
the reason we have it, this is, maybe more than you're interested in, but we've had it from the beginning. Every trial for a while, I was doing all MSJs as well, but every trial has been posted on there. And it's just kind of carrying on with a theme of open courtrooms. And we've had folks appreciate that it's there because then they don't feel the need to be in the courtroom if they wanted to keep an eye on what's going on. I've had lawyers say they love it because they can go back and get the exact quote for what a witness said and then throw that in their closing. And you don't have to go off your written notes or anything like that. I even had people take clips and put it in their closing, and I don't have a problem with that. Assuming we'd have to work through an objection if there was one, but I think it's a tool. I think that to me has more pros than cons, at least as I've seen so far. I've yet to have a juror express any awareness or knowledge of what's going on or that's out there, and I haven't had a witness come out and directly say that they were watching it or really any major suspicions that they had been at a trial. Put it that way.
Your Honor, may
Yes,
I
sir.
address the subpoena issue a little
Sure.
bit further? Okay. So I want to emphasize, we've been expecting a subpoena if they were in fact going to call Mr. Maya. We didn't know for sure if they were going to call him or not. We have been awaiting a subpoena if they were going to call him. When no subpoena arrived, we reasonably concluded they weren't going to call him. So my client and I have been acting in good faith with regard to this issue. They have a legal duty to issue a subpoena to any witness that they want to compel to come into court. And if they haven't carried out that duty, he's under no obligation to appear. I want to contrast this with our motion in limine with regard to witnesses, where they had a clear and distinct legal duty to disclose the parties that they intended to call as witnesses. And then they deliberately chose not to do that and refused to supplement their discovery responses over many months. So in that case, there was a clear violation of a legal duty, which was sanctionable. I know you're not saying that we need to be sanctioned, but it does seem like somewhat of a sanction if you've already verbally indicated that you have ruled favorably on our motion in limine, and now you're considering overturning that ruling based on something that my client has not done wrong.
Your Honor.
I'm sorry, just one other
Yeah, thank
thing.
you. Sorry, James.
I guess that's our position. Did I miss anything?
No, I mean, he was always willing to testify.
Yeah, Mr. Maya actually is quite willing to testify, but he hasn't been served with the subpoena, so he's not here. How is he to know that he's compelled to come into court unless he's served with a summons to do so?
Well, it was certainly, I mean,
We don't need to go round and round about this. I understand the position. It's noted. And at this point, as I think I'd indicated before, with the exception of Mr. Maya and your interrogatory motion in limine, I hadn't ruled and made any definitive rulings yet. And on Mr. Maya's, I had said that exclusion of his testimony entirely, I didn't think was the appropriate sanction. So on that issue alone, we'd gone from there. But to your point, I think I am ruling in with, as you suggest, which is if you want a witness here, that witness has to be subpoenaed. And right now there isn't one that's been subpoenaed that he's trying to call. And you are under no legal duty to have that witness here. But in terms of all these other aspects, we take them as they come. So with that, I would.
Your Honor, if I might.
Okay.
Please, just the last comment on this issue. The pretrial order that you signed in this case was filed on July 1st. That's over 2 months prior to today. All of the witnesses, except for the character witnesses in Sam Summer Benton, are well known to them. And they were listed in pretrial order.
I mean, I would say in your motion to compel, you listed Ed Smith as a material witness. That's how
Right,
you
I mean,
described him.
He's presented affidavits that have been reviewed by this court.
I think that was 2024.
And so, for them to say that it's some sort of surprise, my understanding is it's not, if you don't list them and they're not on the pretrial, then it's out. But there's been no surprise. They knew who they were. It's listed on the pretrial. They had 2 months to take a deposition if they wanted to. And now they're trying to lay back on some procedural issue in order to prevent the jury from getting the full facts of this case. And that's not right.
All right. So again, until you actually give me an indication that you are in fact wanting to call one of these people, I think we've we've covered the issues and they're well flagged should they come back up tomorrow. But for now, we have the path forward, which is 9 a.m. tomorrow. Plaintiff may call their first witness and we'll go from there. All right, we're in recess until tomorrow. Take care.